Tonight, the Attorney General seeks up to 25 years imprisonment for Galamsey kingpin Aisha Huang as he returns to court to challenge decision of the court to slap 4 years, 6 months jail term on the notorious Chinese national.
When we arrested her last year, there was no evidence that when she came back to Ghana, she committed illegal mining offenses. No evidence.
Did you look for it?
Oh yes, no evidence.
But does the AG have the evidence to secure a stiffer punishment? We will examine that. Plus, Forestry Commission points finger at Attorney General's Department as case against a contaminating affiliated with MPP Ashanti Regional Chairman stalls.
The docket has been sent to Accra, and they're going to seek advice from the Attorney General's Department. And so far, we haven't had any feedback.
This is Top Story with Evans Mensah.
And Top Story is always brought to you by Vodafone. It was just yesterday that the Attorney General scored a big win, securing the conviction of the Chinese Galamsey kingpin Aisha Huang, who was jailed 4 years, 6 months. 24 hours on, the Attorney General says he is dissatisfied with the decision of the court and is set to challenge the court, seeking up to 25 years imprisonment for the notorious Chinese national. But it comes after the AG's office had defended the court's decision. Now, listen to the Deputy AG, Godfred Yeboah, explaining on PM Express last night why the court was unable to use the amended act that imposed a minimum of 20 and a maximum of 25 years for the crime Aisha Huang was convicted of.
Now, in our criminal jurisprudence, the time that you commit an offense is the very time that you use when you are being punished. So if you commit an offense in 2015, and the punishment then was punishment Y, and you are tried in 2020, where that law has even been repealed, per our laws, when it comes to punishment, you cannot be punished under the new law, but rather the existing law at the time that the person committed the offense. In this particular case, Aisha Huang committed the offenses between February 2015 and May 2017. And 995 came into force in 2019. So obviously, 995 is out. Now, if you look at our constitution, Martin People, I think you may have to look at that. Article 19.6, if I may be permitted to read here, says no penalty shall be imposed for a criminal offense that is severer in degree or description than the maximum penalty that could have been imposed for that offense at the time when the offense was committed.
Which act is it?
Article 19.6
in the Constitution.
Of our Constitution. So it's so clear. In our Constitution, if you are being punished, we look at the law at the time that you committed that particular offense. That one is not alone. If you look at our Interpretation Act, which is Act 792, Section 35, 2E, it's also the effect that when any act is repealed or substituted, when it comes to punishment, you cannot punish more than what you had in the existing law. However, if the new law has reduced the punishment, you should punish the person under the new law. That is our law. So it's so clear. Article 19.6, then Section 35, 2E of our Interpretation Act. So the judge actually digested these two provisions and came to a conclusion that she had no option than to punish Aisha Huang under.
So this boiled down to when the crime was committed.
Exactly.
So let me ask then. Aisha Huang was rearrested in 2020. So when we rearrested her, why didn't we use the new law, the amended act, which was passed in 2019?
When we arrested her last year, there was no evidence that when she came back to Ghana, she committed illegal mining offenses. No evidence.
Did you look for it?
Oh yes, no evidence. As I speak, if there's any evidence that when she came back, she was engaged in illegal mining, that would have been another.
She was arrested somewhere in Ashanti region.
In September, in Ashanti region.
Ashanti region.
Yes.
She was definitely, I mean, without even knowing what the evidence said.
The law
must have been involved in some form of illegal mining.
The law is about evidence, but not speculation. Do you have evidence that when she came back in 2022, she was into illegal mining?
The state must find the evidence.
We didn't get it.
Did the police investigate it?
Nothing of that sort.
Did you just automatically just use the old offense?
You see, let me give you this information. This is a case where citizens of this land actually helped us in prosecuting this lady. We had farmers, about 6 of them, who came to court testify that Aisha Huang came to them, bargained with them for their land, sometimes 1 acre, half acre, for her to do illegal mining activities. Apart from these pieces of evidence, immigration also came in. They dealt with the issue of immigration. And in fact, in this particular matter, immigration did so well because they arrested her in 2018. And thereafter, she was sent to court and then she was deported. Then she came back. But when she came back, not a scintilla of evidence exists that she engaged in illegal mining. But prior to 2022, when she was deported, there was enough evidence. And that's why we decided that we must prosecute her based on the evidence available. You don't go to court without evidence only for you to be defeated in court.
The Deputy Attorney General there on PM Express explaining why the trial judge had no other choice than to impose the 4 years, 6 months instead of what, of course, some people had called for, which is a maximum of 25 years imprisonment for Aisha Huang. In fact, yesterday at the Joy News National Dialogue on Illegal Mining, there was criticism. Listen to Ken Ashigbe, who raised the point exactly about his expectation that more should have happened in this case.
One of the points that have to be made is about this lady judge that's handling this case. Right from the onset, considering Aisha Huang as a flight risk, the positions she took, and the fact that she was very nationalistic in the doing of her job, you just have to position her against the judge. I think it was one quest in Takwa, who prosecuted, on whose court they prosecuted some 4 Chinese people. And he, in sentencing these foreigners, sentenced them to the minimum sentence for Ghanaians. You know, just a fine of 2,400 Ghana cedis. And seeing that finally we have got some conviction. My only pain is that apparently, when we rearrested Aisha Huang, we still were prosecuting her under the old law. And my question I ask is that when she was rearrested, coming back again, was there, I think that was one of the charges. And then did she not get involved in any mining activity for which then the charges should have been under the current punishment regime? So yes, it's great that we've seen some prosecution of somebody who is not just one of those people we find in the forest reserves, and we've been able to get to the point where we're getting to. And I agree with Nana when he talks about getting to the basis and finding out why this thing is happening. But and again, when Doc talks about the fact that we're going to go into an election next year, and if you look at what has happened, the sinusoidal dances we've been doing, and we are confronted with such grave challenges as a country, but I don't think we are passionate enough. And the Forestry Commission, unfortunately, I don't believe you're doing enough, to really be able to resolve the issues.
We also heard from former Environment Minister, Professor Frimpong Boateng, on this subject, and he also wanted more.
I believe that the law was changed, and the minimum sentence was supposed to be 15 years. So that's what I know. Thank you.
So it should have been 15 years instead of what we had?
Minimum.
Okay, the Attorney General has been responding to that.
Yes, the Office of the Attorney General has not been very, very happy. You know, the issue of Galamsey has become very topical, and so people were expecting that Aisha Huang would have gotten stiffer punishment than what she got. And so the statement here reads that the Attorney General has been drawn, the Office of the Attorney, or the attention of the Office of the Attorney General has been drawn to various misleading comments by some sections of the public in reacting to the judgment. The AG hereby respectfully entreat members of the public, including lawyers, to be mindful of the facts stated above and desist from comments which not only jeopardizes the sound and efficient administration of justice, but also undermine the fight against illegal mining. In fact, the next paragraph states that the Attorney General expresses appreciation for the relatively swift manner, a little over 1 year, in which the justice has been dispensed in this case. It underscores the commitment to the punishment of illegal mining offenses. And here is a big one. Whilst applauding the efficiency of the justice delivery system witnessed in the Aisha Huang case, the Attorney General will, however, test the soundness of the decision of the trial court to punish the accused person under Act 900 by filing an appeal at the Court of Appeal against the sentence in a bid to ensure that the new sentencing regime required by Act 995 is applied to the accused person. It's signed by the Attorney General Godfred Yeboah Dame.
And this statement, the earlier part of it, just reiterates the point we had from Tian Yeboah, who's the Deputy Attorney General, explaining why the judge had no choice than to use the 2015 Act.
Exactly, because
imposed a maximum sentence of up to 5 years.
Because he indicates that the crime was committed during that period when the new amendment to the Minerals and Mining Act had not taken place, and so they had no option than to use that one in prosecuting Aisha Huang.
Okay, thankfully we can speak to the Attorney General, Godfred Yeboah Dame, who joins us right now. Thank you, sir, for your time here on Top Story.
Thank you very much, Evans.
Great to have you.
And good evening to your cherished listeners.
What changed? Yesterday, we had your deputy explain why the judge had no choice. Today, you want to appeal. What has changed?
Hello?
Can you hear me?
No. Hello?
Can you hear me?
Hello, Evans.
Yes, I can hear loud and clear. Can you hear me?
Yes, I can.
Great.
Yes, better now.
Yesterday, we had your deputy explain why the judge had no choice than to use the 2015 Act. Today, you want to challenge that. You want to appeal. What changed? What has changed?
Well, I think it is important to note that the judge indeed had legitimate basis for sentencing in the manner in which she did. And indeed, if we take a careful look at our statement, we have not sought to harshly criticize her or to raise any serious qualms about the decision. The point we make is that, yes, there's a new sentencing regime, punishment regime, and our respectful view upon a careful consideration of the issues is that the judge ought to have applied the current law, because indeed she's been punished today. Yes, the judge had legitimate basis, I say so, because of the constitutional provision in Article 19, Clause 6. But that provision itself and the manner in which it ought to be construed and applied, for me, lends itself to multiple interpretations. And if you look at the jurisprudence of our court, there's a basis for us to question it. And I think there must be pronouncement by a higher court. So consistent with our quest to ensure that there's finality to this issue and there's clarity as to the kind of punishment that ought to be imposed in a matter as serious as this, I think it's worth the while to appeal. So I made the point that, yes, the decision to appeal will just be to test the soundness of the judge's imposition of the sentence. We are happy with the conviction. We're happy with the efficiency with which justice was dispensed in the manner. And the records will show that this is actually the first time an acknowledged kingpin of Galamsey activities in the country has been successfully prosecuted and it's been punished. And I think it is deterrent enough. It will send the right note of caution to all foreign nationals and indeed even nationals of our country who are engaged in such an act. But our view is that the new punishment regime that has been put in place by the Parliament of Ghana since 2019 ought to be upheld, respected, and applied in this case.
But how so, considering what your deputy explains, that it boils down to when the crime was committed and that you didn't find any evidence?
Hello, the line is a little unclear.
Yes, can you hear me? Can you hear me?
Yes, I can hear you now.
I mean, I'm just asking, how so, considering the explanation we got from your deputy, that it boils down to when the crime was committed and that you did not have any evidence to suggest that post-2019, when this act came into force, there was any evidence that Aisha Huang had indeed engaged in illegal mining?
Yes, but of course, we did not charge Aisha Huang for offences committed after 2019. I think that is undisputed. So my deputy, with all respect, has not contradicted the office in any way at all. My deputy has not said anything different from what I'm saying today. My deputy actually stated the reasons why the judge sentenced in the manner in which she did. And I said, well, she cannot be harshly criticized, and that is because indeed the offences were committed in 2015, she was not prosecuted. Some were committed in 2016, she was not prosecuted. And then it ran up to early 2017 when she was arrested. And of course, there was prosecution in 2017, but which was terminated in 2018. And then, following her re-entry into Ghana, we decided to arrest her and prosecute her for those previous offences. So it is not in doubt that the prosecution was in respect of offences committed in 2015, 2016. And so really, in such circumstances, we think that a judge may have legitimate basis for sentencing based on the sentencing regime prevailing at that time. But another judge could also take a different view, which is that the sentencing regime applicable as the date of conviction is what ought to be applied. Because my view is that to the extent that at 995 had actually repealed all those provisions, it may become a little incongruous for and indeed, one material point is that the accused person was actually tried under Act 995. And that is why I find it a little incongruous or inconsistent to hold that when it comes to sentencing, at that point, you are going to apply a different law. I think that is in respect of the law that she was tried under. The offences were charged under Act 995 because the old offences had been repealed by Act 995, substituted by Act 995. So really, the punishment regime should also go with a substitution, in my view. And that is why I think that there's also a legitimate basis for us to test the soundness of the law. So it's actually consistent with our quest to ensure that we go through the full process. We exhaust the avenue possible to ensure that she is punished as severely as possible. Yes, she's been convicted, no doubt. She's guilty of galamsey offences, and we are very happy with it. She's been thrown into jail, and I'm sure within the time that will be appealing, she will still be in jail. And this, she has been in jail right from day one, even before conviction. She was in jail. She has never been released, even for one day. Bail was denied all through, and we're thankful to the trial judge. But I think that the severity of the acts that she committed really should warrant the imposition of a higher.
Mr. Godfred Dame, did you say that she was
the correctness of the decision by the trial judge?
Just for clarity, Mr. Dame, did you say that she was tried under Act 995 as amended?
Hello, pardon me.
Did you say she was tried under Act 995 as amended?
Yes, please. Yes, that's it. Because at that time,
because that's the act that says minimum of 20, maximum of 25.
Pardon me?
That's the act that says minimum of 20, maximum of 25.
20 years. Yes, minimum 20 years for a non-Ghanaian.
But if she was tried under that act, then it begs the question, I mean, why didn't she get that then? Why was she then sentenced under the 20?
But that is why I'm appealing, precisely. That's why I take the respectful view that indeed there's a literate basis also for my appeal. Because and indeed, it is important to note, and sometimes the media, with all respect, have to follow the proceedings quite seriously. At the point of submission of notice made by the accused persons, the question as to the lawfulness of our charges or the constitutionality of our charges was raised. And the judge ruled that, yes, our charges were constitutional, were in line with the Constitution. And so I think that even the lawfulness of our charges has been upheld at the submission of no point stage. Then if goes without saying that the propriety or the lawfulness of sentencing the accused person under that law should also be upheld. That's why I said that I found a little bit incongruous that at the point of sentencing, then the judge would resort to the law prevailing in 2015 or 2016. at the time that the offences were committed. But indeed, I have also made a point that I can understand the trial judge in a way, because the trial judge clearly was also mindful of the constitutional provision in Article 19, Clause 6, which is to the effect that if you sentence a person, and at the time that the offences were committed, there was in place a law which gave a much or a more lenient sentence. Then you apply that law. Article 19, Clause 6 clearly, and I think it's very important for me to quote at this word. It says, no penalty shall be imposed for a criminal offence that is severer in degree or description than the maximum penalty that could have been imposed for that offence at the time when it was committed. So this provision raises the presumption that indeed it is proper for a judge to apply a penalty which is not severer than the one in place at the time that you are sentencing the person. If indeed the act was committed at the time that the law applying to the offence was less severe. It says no person shall be imposed, or no penalty shall be imposed for a criminal offence that is severer in degree or description than the maximum penalty that could have been imposed for that offence at the time when it was committed. So as I said, there are two schools of thought in all of this. The judge, yes, was entitled to take this school of thought, which of course mandated the imposition of the penalty prevailing at the time that the Galamsey offence was committed in 2015 or 2016. But I am also of the view that if indeed the same judge had also upheld the constitutionality of the lawfulness of our charges, then logically he should have proceeded to also punish under the same as 995.
But also further clarity, Mr. Dame. If she was, I can hear you. If she was tried under 995, which of course came into force in 2019, is there evidence that she committed crimes post 2019 when the law came into effect?
No, because the accused person was deported from the jurisdiction in December 2018. And then she re-entered the country. The specific time that she re-entered the country, I mean, is a little questionable. But she was arrested on 6 September 2022. And she was not arrested on a mining site. She was not arrested in the act of committing any illegal mining. She was just identified in Kumasi, spotted in Kumasi, and then she was arrested. So in terms of specific evidence of acts that she committed in 2022, really there was none at all. But of course, I mean, I made a promise to the nation that yes, she will be tried for previous offences, all offences committed, as well as the current offences that she had been committed. Investigations reveal that, properly looking at the situation, the only offence that could be preferred against a person in respect of act committed in 2022 was the act of re-entering the country without permission, contrary to the Immigration Act.
But that's precisely the point, right?
The Galamsey offences, it is actually the past offences that she had committed.
Yeah, but that's precisely the point, Mr. Dame, that if you don't have any evidence to show that she committed crimes related to Galamsey, for example, post-2019, laws don't take retrospective effect. So how do you expect on this appeal to apply the 2019 law when there's no evidence that she committed a crime there?
Yeah, but that's the point we have always been talking about right from the beginning. I mean, that's what I'm saying, that indeed that is the basis on which the trial judge imposed the punishment applicable.
I only ask that because you're going on appeal.
And I'm saying that
on the strength of the 2019
I'm saying that indeed the charges preferred against the accused person were under Act 995. And the legitimacy, the lawfulness, the constitutionality of those charges were upheld at the submission of no case stage. So we succeeded in showing to the court that indeed, notwithstanding the repeal or the substitution of the previous law by Act 995, a case could still be made for her prosecution, and that was done. And I'm saying that if we look at the constitutional provisions, not only Article 19 Clause 6 in isolation, if we look at the provisions as a whole, you punish in respect of an offence, the penalty for which has been created by the law, and the law that the person was charged with. was at 995, and the penalty has been specified in that law. So I think that it is worth the while for us to pursue this to its logical conclusion and to ensure that if it is allowable, the maximum penalty ought to be inflicted on the accused person. If the Court of Appeal takes a contrary view, we may ultimately go up to the Supreme Court, which of course is the highest court to pronounce on constitutionality or to pronounce on whether enactments are constitutional or not, to give an interpretation on this issue. And the Supreme Court rules, we're bound by it. But I think that is worth the while. The most important point is that, yes, the accused person was arrested and she was in custody throughout the trial. And after the trial, conviction was secured and she was punished and she will be in jail for the next 4.5 years. And I'm sure we'll exhaust all these processes before the end of the next 4.5 years. And so we'll get to know whether the Supreme Court or the Court of Appeal will impose a higher sentence or not. If the Supreme Court or Court of Appeal takes a view that the trial court was right, then we'll be bound by it, and the 4.5 years will apply it.
Mr. Dame, while I have you on, yesterday the Forestry Commission Executive Director, on a separate matter that has become issue of public knowledge because your colleague, Lands and Natural Resources Minister, spoke about it, and it relates to Akonta mining, that they were engaged in illegal mining in the forest. The Forestry Commission also confirmed same. The Minerals Commission confirmed same. The Forestry Commission yesterday at our national dialogue on illegal mining says the docket was submitted to your office for advice, and since then nothing has happened. Can you tell us what has happened to this case?
I'm not aware. I'm not in the position to speak to this issue because personally I don't have such information. I'm not aware. I'm definitely in the position to comment on it. But of course, if there's basis, I've said time and again that if there's basis for us to prosecute, sort of a docket that has been built on the back of solid evidence, no doubt we'll prosecute. Recently, an RTR request was sent to my office by Sabri Jefi also. We responded to it, and we indicated that, yes, if he has any evidence, clearly he should make a complaint to the CID. I don't know if he has made such a complaint to the CID. So clearly my office is in the position to, and is always willing to prosecute any matter that has been thoroughly investigated. We not just go to court in the expectation that innocent persons will be harassed and ultimately they'll be released or free at the end of the day. We do not do that at all.
Thank you very much. That's the Attorney General, Godfred Yeboah Dame, there. And thankfully, I have two of the activists on the line and who have been pursuing this matter quite vigorously, both the Akonta mining matter, but also this Aisha Huang case. And that's Ken Ashigbe. Of course, he is the convener of the Media Coalition Against Illegal Mining, and Martin. But Martin, we've just heard the Attorney General say that the Aisha Huang was prosecuted on the act that was passed in 2019, Act 995. What's your reaction to that?
Yeah, so it's good that the Attorney General is going on appeal. It will strengthen our jurisprudence. Yes, so that's good. It's good, you see, because forget that justice emanates from the people. So when there is a groundswell of disappointment with the sentence, and citizens are asking that why can't we use the new law? It's good to test the law because, Evans, today you are largely talking to me because I've tested a few laws in the Supreme Court and they worked. These were laws that some people told me that, I would not win. And lo and behold, I won. So there is no harm in trying. So it's good the Attorney General is saying that he's going to go on appeal. That is good. Let's test the law. And let's not also even forget, look, Evans, when you go to England, and even we have all benefited, the Court of Criminal Appeal, it is actually as a result of complaints made by journalists. That's how a Court of Criminal Appeal was created in England. It was the work of journalists complaining about injustice. And so for us in Ghana, we just copied from the British. But what we need to realize is that it's citizens who complain. Citizens make noise. And out of the noise, then there is some wisdom. So in our democracy, there can never be statements such as people should stop making noise. No. I could give you several other examples. It is out of the complaints of people. Even the Magna Carta, the famous Magna Carta, how did it come about? So you always find that it is when citizens make noise. Sometimes it will look like, that is not the law. Do you know the law? Why don't you go and talk to a lawyer? No, that's not what we are talking about. justice emanates from the people. So sometimes you can have a clear law, but where it doesn't sit well with the citizens, out of the noise the citizens make, you are able to fashion a new law. So this one, it's good.
Martin, give me a quick comment on the revelation that actually Aisha Huang was prosecuted on 995.
Yes, that's fine. You certainly have to prosecute under 995 because Article 19, Clause 11 says that you can't prosecute somebody when there is no written law, when it is not a crime. Okay, so I'm just paraphrasing. So under 19, Clause 11, you can only prosecute somebody when there is a written law criminalizing a certain conduct. So if at the time they were prosecuting Aisha Huang, the Act 900 had been repealed, you cannot go and use the dead law. Or there are a number of cases. I think there is Banda versus the Republic. It didn't even start today. There are several other cases.
But I guess the real question is. But I guess the real question is, if it's 995, then why not 20 years minimum and 25 years maximum?
So that is excellent. That's your $1 million question that the AG is going to test. We are all learning. It's good. Let's wait and see what will come out of the appeal. And you never know. Even if the appeal doesn't succeed, as I said, the value is in the noise. We must always encourage the noise. So we also want to tell the Attorney General that part where he said the citizens shouldn't make noise, no. Next time, he shouldn't write that. Look, we've benefited from a lot of noise. It's in the noise. The noise kind of nudge people in authority. You see, it kind of juggles people. Then you rouse from your, stupor. Like the way Socrates calls himself a gadfly. The gadfly makes noise. You see, the gadfly, when it bites you, then you rise from your stupor. That kind of thing. So noise is useful, very, very useful.
And Ken, what's your reaction to what we just learned there? I mean, the same question. 995 was used, so why not minimum? You raised the point yesterday. Why not minimum 20? Ken Ashigbe, if you may. Hello, Ken. Do we have Ken Ashigbe on? Okay, I doubt if we do. But also on the second subject of our contaminating, Martin, this is something that you've been pursuing. Yeah. You just heard the Attorney General explain to us that he doesn't know about that case. Although yesterday we heard from the Forestry Commission that the case was sent to the Attorney General's office. In fact, I've just received clarity. You were on the show on PM Express yesterday when the Deputy Attorney General says he will check and return with feedback on whether they have that case or not. He has sent me the update. He says they do not have the docket, and the docket has not been submitted to the office of the AG, and that the police say they are not done with investigations. So that's the update there, Martin, on Akunta mining.
Evans, the first part of the Attorney General saying that he doesn't know about Akunta mining. Once again, you see, Attorney General, he should realize that, look, we are 32 million people. Some of these statements don't bode well for our governance.
He was speaking specifically in reference to if he had been submitted to his office.
I'm not sure that's what he said.
No, that's not what he said. So what said,
exactly. The issue about what the Forestry Commissioner had said that the docket was what he was talking about.
So, Martin, that's what he was saying, that if the docket, as far as the docket is concerned, he can't say if they've seen it.
Good.
And the deputy confirmed. And the deputy confirmed that they don't have it.
My point is so substantially the same, which is that, listen, looking at the damage that Akunta mining has caused us as an AG,